This channel does not promote any violent, harmful, or illegal activities. All content provided by this channel is meant for an educational purpose only.
Yes, y'all are the job losers. Are y'all the
untainted?
untainted job losers? Then
Lord, I just request you to your lordships to come at prayer B. At my pagination 35, my junior is saying it may not tell. It will tally. And that's okay.
B.
B. Malad, a writ or in the nature of a writ in declaration declaring that the Kolkata Gazette dated 29th May 25, that is to say the rules of 2025 issued by the Office of the Principal Secretary Government of West Bengal and notification dated 30th May 2025 advertisement issued by the Commission as being ultravirus to the Constitution of India. Now, my lord, I give you lordships this copy of the writ petition WPA number 12512 of 2025, Orunima Paul and others, the same prayer.
Yes.
Same, exactly the same prayer. Now, this writ petition was dismissed. Then Malad went up to the division bench and then Supreme Court, affirmed the judgment of the learned single judge. Therefore, Malad, my first submission that is no longer open to question the varies of the same rules again and again and the notification.
Yes.
Then the second point, your lordships, we also question, my lord, this, my lord, jumble upping of the two process in a single rules. গরম পড়ে গেল ঘাম হচ্ছে রে। That our division bench directed to proceed afresh, but against the existing recruitment, then existing 2016 recruitment process against the same vacancies. But this was, my lord, merged with the subsequent vacancies under new rules. We questioned it, my lord. What I'm trying to make out, but we could not succeed. We tried to make out this case before this court.
Which case?
That's I give you lordships that that's I give you lordships the namta bol. We have taken filed our affidavit in opposition. That's at page 9.
ওনার অপোজিশনটা একটু দিন না
উজ্জ্বল মাঝি তো
এই মামলাতে অপোজিশন আন্ডার হুজ ব্যাকশিট উইল ইট বি
ব্যাক সিট শ্রীমন্ত page 9, Roman paragraph Roman 12, that at the very instance the untainted teachers have moved several writ petitions, one of which is WPA 12713 of 2025. Malad, this is Malad Ujjwal Kumar Majhi.
Yes.
Now kindly see your lordships prayer C. A writ or in the nature of a writ of mandamus calling upon the respondent authorities to issue notifications for separate selection test in regard to untainted candidates of first state level selection test of 2016 following the selection rules of 2016, and the separate selection test may be conducted for candidates who had not been participated in the first state level selection. That means freshers.
That means you wanted the 16 candidates to be tested separately and the fresh ones to be tested
But
separately.
this exactly thing this happened, your lordship, in respect of primary teachers recruitment in 2009 and 10. In respect of 2016, 6 process could not be continued because of the judgment of the our pendency of the our writ petition, your losses in regard to that training was given by the institutes which are not recognized because of pendency of that was not. Then Malad, when 2009 after the judgment 2009 notification issued, this club together. Malad, our High Court's judgment went up to the Supreme Court. Initial judgment was passed by the Honorable Mr. Justice Soumitra Pal.
Whoever.
No, this cannot be clubbed.
Cannot
But
be
Malad,
clubbed.
we have lost. This point was raised, but we were lost. Point is that, my lord, therefore, clubbing was allowed by this. Now, the point is that, your losses, if the clubbing is allowed on the basis of the rules, so rules, my lord, whatever benefits have been given in the rules for 2016, only, my lord, the experience. So that was also, my lord, upheld by the Supreme Court twice by this. Once, your lordship, first Arunima Pal, and then again. And the Supreme Court, my lord, in the subsequent judgment dated 26th November 2026, my lord, 25, sorry, my lord, this should be 25, my lord, made certain, my lord, observations, your lordships kindly see. Now the observations takes the character of the obiter dicta. If your lordships kindly consider that page, last page, my lord, your lordships need not, because everybody praised your lordships so much. The last paragraph, the High Court shall also be mindful of the fact that the untainted candidates in the past selection were allowed to sit for the selection test to be held afresh, and their candidature cannot be adversely affected by the application of the new rules. That is, the West Bengal School Service Commission rules, such and such. Now, my lord, what I am trying to make out before your lordships, that anything which, my lord, prejudices the cost of the per service of the untainted teachers, that should not be allowed. Per service, my lord, always taken into consideration in the service jurisprudence. Always. My lord, untainted teacher, they allowed, though ultimately losses service was not, that is because of the state fault.
But then what has this got to do with the 10 marks and everything?
Well, the 10 marks has to be given to them. That's what I'm trying to make out. 10 marks has to be given to the untainted teachers. That was one of the rules. If they have the past experience, they can show, satisfy. Obviously on the basis of records.
Assuming this 10 marks is not given, even then also you are not adversely affected.
Obviously adversely affected, because this is my past service. Lord, I have earned it because of my by dint of my service.
In the 2016 recruitment process, this past experience was not taken into consideration.
Not, but your lordship, when the new recruitment rules comes, it takes into consideration.
And you want to take advantage of it.
It's advantage, not this is benefit, legal benefit to me because of my past service. It's not the question of advantage, my lord. Law gives me.
Yes.
And your lordships,
on the basis of the law.
That's your lordships. On your lordships, kindly see the line of judgments in this respect of this recruitment process. Untainted means, my lord, I was not involved in the selection process in any sort of illegal activities. That's why one submission I made, your lordships, there are 3 categories in one matter. My lord, OMR blank sheet. Of my lord, blank sheet, my lord, blank OMR sheet, mismatch of marking, and the other thing, out of panel. If your losses leave aside these 3 categories, I could have been in the list and I could have been declared untainted. Even I would have been given the clean sheet. Now untainted, untainted also every time publics in social media, it gives some stigma towards me also, unnecessarily. This court, up to the Supreme Court, has specified that these are the categories. But this can be, if your lordships apply the principles of wedding out. Supreme Court long said in 1995, but didn't apply because of the conduct of the state. This could be pointed out to your lordships. Now, certainly I know your lordships will take out, how can I, this is the Supreme Court has done it, I know, but your lordships have been given every power to do it, to consider afresh. Kindly see the plight of these candidates. Nobody says there is a mismatch of marking, nothing, blank OMR sheet, not out of the panel. There was somebody maybe in the waiting list. They could not have in the waiting list even. They could have in the main list. Had this illegalities are not done. Give some consideration to this aspect, your lordships. So because of this, my lord, 10 marks. My lord, I know what is passing through your lordships' mind, but I am not on that. That, my lord, this have not been touched even by the Supreme Court because of this Orunamapal matters. So this has happened. And now I tell your lordships what? Because of this I am, my lord, saying that anything, my lord, any interpretation given to the rules which goes contrary to, that should not be allowed. My lord, I tell you lordships one thing. Once a candidate selected, my lord, of course, unblemished. My lord, if your lordships ask someone to appear with the freshest candidates after 10 years, it's very difficult, your lordships. It's very difficult. In a competitive examination, competitive marks, pattern of question, pattern of syllabus, everything goes. So that, my lord, should your lordships consider that. And consideration of past service is, my lord, well recognized, my lord, in the service jurisprudence. And consider that, your lordships, one thing, your lordships, in the when these 2016 rules, my lord, total marks was
35
academic score, my lord, total marks was 35. Now is only 10. Kindly, this should have some bearing, my lord, implications in the findings of your lordships. Now I was selected, untainted, and then your lordships, my lord, on the basis of academic score under the then rules, 35. Now it is 10. I have to compete with them because of these 10 years, my lord, pattern of marking in the public examinations, Madhyamik, Uccha Madhyamik, all, my lord, have changed. Nowadays, my lord, nobody gets below 90. If somebody gets below 90 or 95, my lord, she is not taken into consideration even, my lord. Some of the schools do not allow them to fill in the forms. So these are the things, your lordships, to be considered. Now your lordships will also consider, I have given a chart, your lordships. They are saying that the 10 marks affects them. My lord, this chart I have given, well, opposition, page 40, ঠিক pagination to 44 তাই আমাদের but 44. What I am trying to make out, your lordships, out of this, your lordships, I will not nitty-gritty of it. My lord, this chart, my lord,
Page 46
page 44
of
my affidavit in opposition.
yes, 44. Yes.
But I have given details.
total number of fresher candidates.
My lord, your lordships will find at the last column total number of freshers candidates called for interview 9488. Last column, bottom. My lord, against, my lord, therefore 50% of the freshers have been called up for 11-12. What's the prejudice caused to them? Visualize, your lordships. Total marks have been reduced so far we are concerned. They are getting 10, we are also 10. But when I was selected, it was 35. So this is not the case that they are affected by this process. I am not taking your lordships to the details. My lord, each breakup I have given, EWS, general, OBC, all that. And I give your lordships one fact. My lord, in 2025, my lord, total vacancy in respect of 11-12 declared vacancies, of course, 12,514. So against them, my lord, whatever may be the ratio under the rules called on, my lord, more than 50% are the freshers.
68%. 68% fresher পেয়েছে 90 lakh.
And the another chart I am giving up, onader dao, giving up, this is not, but it took little time, your lordships, kindly take up this.
Where from y'all are collecting this data? From the site?
Site, all are from the site. Kindly see, your lordships, preliminary interview panel. Now your lordships will find here the total, this is in relates to 9-10. Total vacancy, your lordships, কালকে যে একটা অন্য digit না,
Total vacancy হচ্ছে 11.
after deducting your lordships 12,514, I find total your lordships here now 22,240.
Repetition এ আছে total vacancy.
This I have writ petition also includes this, your lordships will be getting it. Then your lordships kindly see, called for interview 39,000, page 23 of the writ petition also, that's not the total. Called for interview 39,207. Now freshers, 27,010. 68.89% freshers have been called up. And we in service, 12,000, number called 12,197, 31%. How one can say that they are affected? Kindly consider we have secured these academic marks in 10 years back. And now your lordships sitting with them, with the freshers, candidates having freshers mind, having all throughout, they have, my lord, appearing in the competitive examinations, all that. But once you get a job, your lordships loses the, my lord, that.
Interest to study.
Study not, my lord, competitive examination. One has to study as a teacher. But
Outdo yourself.
no, but competitive examination, your loss is something else. Something else. So many things involved. Here, my lord, we can say someone has not tick, somebody has not encircled. But in the hall, my lord, even a brilliant student sometimes commits mistake, which is not, my lord, can be comprehensible to be human being. But it's a mistake, simple mistake. So, my lord, it's very, my lord, I have seen even a candidate all throughout first. He had given two, my lord, in the CAT, 2 examinations, 2 papers. First, third examination, after half an hour, he said, I don't like it. Give out of that. There are students like that. But in the system, he has to be declared failed. So, my lord, it's very difficult now. What I'm trying to make out to your lordships, 10 marks doesn't put me at the top. It gives some considerations in that because of my past service. I'm not, my lord, stealing march over someone else. It's a recognition, but, my lord, sorry to say, because of the state activities.
Yes.
Then, therefore, I tell you, losses, my lord, rules recognizes it. Competency cannot be questioned. It's up to the Supreme Court. It's go on repeating and reopening, my lord. This should not be allowed according to my submissions, your lordships. These are my humble. And adopting, my lord, I'm of course
Whatever has been.
Mr. Anindo Mittal, because I my lord, accept all of my senior submissions. These are my humble submissions.
All right.
Much.
Lord, I'm sorry. I guess, Lord, I am the last Lord of the added
Applicants.
respondents. Lord, as I speak, Lord, I don't think that there's too much for me to add. There's just one or two very simple points, my lord, which I may remind your lordship, my lord, because it's been
Who are you representing?
item number 50, can number 5, Saurav Acharya.
এটা বোধহয় অ্যাড হয়নি না?
Rahul Mondal.
আচ্ছা ঠিক আছে।
Lord, the first thing that your lordship, Lord, marks is Rahul Mondal was unsuccessful. On that score itself, my lord, the writ petition should have gone. That's one aspect in the matter. So this not being my lord, a public interest litigation, his personal
এখন এখানটা আমি দেখছি।
his personal affectation, my lord, is not there.
He is unsuccessful where?
In the he's not there, my lord, in the interview at all. He was not called for the interview, if I'm not mistaken.
Interview was later on. He filed.
Yes, my lord, he filed it earlier. So now, my lord, it becomes
No,
redundant. But anyways, my lord, that's one part of the matter. That's fine, my lord. Now, I shall address your lordship only with respect to the 10 marks. Nothing beyond that. Now, my lord, this 10 marks, as my learned senior friend just now said, that was a subject matter, my lord, in a previous litigation. Now, this was, my lord, countenanced by them, saying, my lord, that the rules were not challenged there in that writ petition, because there's a line written in that
is it
judgment.
Arunima Paul?
Yes, my lord. Now, in the Arunima Paul, my lord, this 10 marks and why this is fine was discussed. I shall place just 2 paragraphs, my lord, from that judgment. My lord, that might not be, it might not be, my lord, res judicata, but then, my lord, the findings are binding upon your lordship, that being of the division bench. My lord, kindly takes up Arunima Pal's judgment and takes up, my lord, paragraph 31st in that judgment. Your lordship has it, my lord. If not, I'll Arunima Pal's judgment. আছে?
ইয়ে অনিমেষ বাবু এই বান্ডেলটা একটু দিন তো আমাকে।
It should be there, my lord, even in my
Your application, is it there?
yes, my lord, in my application it's not there, my lord. It's here.
Wait. I'm going on adding up papers.
But there are the
এইটাতে হবে না, এইটা দেখি।
there's a compilation which has been given, my lord.
By the commission.
Judgment.
Eight Shahib, eight. In this compilation, my lord, page 128.
Division bench 150.
My lord, your lordship takes up the division bench itself, my lord, at 152. Takes up, my lord, paragraph 30. Internal page 19. I'm not going to trouble, my lord, the entire. Kindly comes down, lordship, kindly got that? Comes down, my lord, paragraph 30. Last line. According to the petitioner's distribution of marks, that is 10 for prior teaching experience, 10 for interview and 10 for lecture demonstration ought not to have been provided, which would grant the recruiting authority and the interview board unbridled power to allot marks indiscriminately. So this allocation of 10 marks was a subject matter in that writ petition before the single bench as well as the division bench. Then kindly comes down right at the, my lord, it be profitable, my lord, if your lordship sees paragraph 32, how, my lord, this was dealt with. And I'll show your lordship below 3 paragraphs, my lord, from this judgment, and then I'll take your lordship to the other judgment.
Yes.
Paragraph 32, my lord. The policy decision of the government is subjected to judicial scrutiny only in exceptional circumstances where it appears that the policy or some clauses in the policy is or are manifestly arbitrary, discriminatory, malafide, unreasonable, or unfair, or if it is found to be against any statute or constitution. If it is dehorsed the provisions of the Act or legislation and if the delegate has acted in excess or beyond its power of delegation, such policy can be declared to be ultra vires, because this is taken to be, my lord, this allocation of 10 marks has been accepted to be, my lord, public policy. Intelligible differentia. This is very important. I'll show a Supreme Court below thereafter. The recruitment rules 2025 per se is not under challenge. This is what your lordship blood fell from your lordship. Intelligible differentia for the purpose of selection of suitable candidates shall not be interfered with unless such criteria appears to be arbitrary. There is an intelligible differentia between unsuccessful candidates and in-service candidates. When an expert body has taken a policy decision with regard to the eligibility criteria of candidates to be applied for appointment of assistant teachers for classes 9 to 10 and 11 to 12, and has elaborately laid down the guidelines, the court in judicial review should not substitute the said views with its own perceptions. Education plays an important role in shaping the society and country. Beloved, waiting here for a moment. Beloved, the state is the employer. The state wants to employ or give employment to, beloved, a certain category of persons. Beloved, what does it do? It, beloved, creates a balance. In my respectful submission, beloved, it is for the persons, the employee, to find out who is the best person, beloved, eligible for the job. Now, when does it become arbitrary? When, beloved, a certain criteria or a category is completely ousted, beloved, from the field. Today, beloved, if a balance is created, beloved, why I say there's a balance? Because if your lordship sees, beloved, a lot of charts have been given to your lordship to show, beloved, how the marks have been allotted and how, beloved, the marks are given, beloved, to the candidates. Now, if these 10 marks, does it, beloved, in any way throughout the freshers? No. But it creates a balance, beloved, where a person with some experience will have certain amount of, beloved, advantage, but vis-a-vis, beloved, the freshers. You can't say in every field, beloved, that a person who has experience will also be beloved, pitted against a person who is a fresher. The government might want somebody, beloved, with some sort of experience, beloved, because this is a specialized job. Teaching is a specialized job. It's not something, beloved, which is open for everybody and anybody. Beloved, if a criteria comes in that somebody who knows how to, beloved, cook is given 5 marks, beloved, to become a teacher, that is, beloved, where, in my respectful submission, beloved, it becomes arbitrary, which has got no nexus, beloved, with the employment which is to be generated. Then, beloved, kindly comes down right, beloved, to paragraph 34. The awarding of 10 marks is a weightage to be given, my lord, kindly got it, beloved? Weightage to be given on the basis of experience, and is only expected that in a selection process of this nature and kind, and all the candidates are required to undergo the rigors of the selection process. In order to select the most suitable candidates, proportionate weightage based on the length of experience to the extent of 10 marks be given to such candidates is not arbitrary. So this is no longer, my lord, res integra. Giving this 10 marks for, my lord, the experience is no longer arbitrary. This is a finding which is final. So whether, my lord, this part of the rule is arbitrary or not, my lord, has already been decided, my lord, in the Orunanga Pal case. This is one part of the matter, my lord, which I wanted to remind your lordship. The other part is, my lord, has it ever been done? These 10 marks been given, my lord, to experience? Has been done. My lord, your lordship has seen Tej Prakash's matter, my lord, my senior friend showed your lordship. It is also been done, my lord, in a more recent judgment. This is 2024, volume 8, SSC 124. Same thing. Volume 8, SSC 124. Let's see the first paragraph once. This batch of 47 appeals involves common questions of law. They arise from the judgments of Division Bench of the High Court of Judicature. The main appeal such and such arises out of judgment of Division Bench. The other matters arise out of same batch as Maheshwar. Then, my lord, 3 is filed. Your lordship need not trouble my lord self. Kindly have a look at paragraph 13. Here, my lord, the 10 marks was given. General knowledge 40 marks, personality 35 marks, experience 25 marks. And a maximum of 10 marks be given according to 2 marks per year for a maximum of 5 years. In a lot of ways similar to what are rules in the 2025 rules. This was formulated, the questions were formulated. Your lordship will find that at page 133, 22.2. Is the award of bonus marks to the projected employed applicants discriminatory and ultra vires the rules? Are the guidelines such and such sanctioning the award of bonus marks on a differential basis for applicants with project experience and other applicants invalid for any other reason? So basically, my lord, experience was given a certain amount of marks. Supreme Court takes it up, my lord. First of all, my lord, it takes up, my lord, if your lordship goes back a little bit, there was a submission which was made, which is recorded at paragraph 16. It just goes back a little bit, my lord. The learned counsel also contend that the advertisement of 31st of such and such did not sanction the grant of bonus marks, and the administrative guidelines dated such and such were not brought in public domain. It was argued that the rules of the game have been changed after the match has begun. This was the argument. It was contended that if the intention of the legislature was to create the set post only for para teachers working in project, the same would not have been offered to private and other teachers as well. This was the submission made. Then, my lord, kindly turns over to paragraph 24. This is the reasoning, my lord, of the Supreme Court, the ratio. See the first line. Fixing of minimum and maximum age requirement is a policy decision. In this case, the said decision, my lord, thereafter it's on the facts of that matter, my lord, your lordship need not trouble my lord self. Kindly turns over, my lord, to paragraph 26. The challenge of the appellant is only to cause 5. We find that the provisions generally including V are not arbitrary or discriminatory insofar as clause 5 is concerned, as has been mentioned herein above. The historical background leading to the enactment of the rules itself provides a justification for granting relaxation to the person serving under the educational project if they fulfill the condition that they were within the age limit when they were initially engaged. As the counter affidavit of the state indicates that the projects were designed to deal with absentee teachers in the far-flung areas, which was causing a serious jeopardy to the education of the rural children, the para teachers, as they were called, worked under difficult circumstances. They had the advantage of interacting personally with the children of the far-flung areas. They only received an honorarium. The projects themselves played a large part in uplifting the elementary education program in the state. The para teachers motivated the children to come to school, probandhok and things like that. Now, 28. No doubt, under the rules, opportunity to apply was also given to all those who possessed the essential qualifications and who had teaching experience in any recognized educational institutions apart from the educational projects. This, however, does not mean that those who served in projects did not form a separate class. There was a valid classification based on intelligible differentia, which distinguished applicants with project experience and those who lacked project experience. This is what it is, my lord, with respect to our matter as well. This 10 marks is given to people, my lord, who have worked on. The government, my lord, in my respectful submission, wanted to create a balance between experience and youth. Can the youth not defeat experience? Yes, it can. My lord, by writing an exam which is of 60 marks, the youth has ample opportunity, my lord, to defeat, my lord, persons who have experience. My lord, if your lordship looks to, my lord, even if a private individual wants to, my lord, employ a lawyer, it's always, my lord, at times, if they can, the persons with experience are always given some sort of a weightage. And it's not their fault that they have, my lord, the experience. But if this is what it is, then every time, my lord, the rule would have to be that there will be no weightage which is to be given, my lord, to experience at all. And everybody will have to have, my lord, that positive playing field or something like that. My lord, there's a very important concept called positive discrimination. My lord, today, if the government feels that these persons having this sort of experience has some sort of advantage in dispensing, my lord, education, the government has a right to, my lord, make its own policy. If it's arbitrary, my lord, if it takes away everything from someone, my lord, I quickly, my lord, hasten to remind your lordship about the Venugopal's case. My lord, in Venugopal's case, what happened? My lord, that's the AIMS director. What happened, my lord, was the entire law, my lord, was framed so that Venugopal could never become the AIMS director. The Supreme Court said that you can't make a law which takes away the right of that one individual. My lord, if you take away a right completely, my lord, that's arbitrary. Here, my lord, an ample weightage is given to people who have some experience. Now, this is in consonance, my lord, if your lordship sees 28 and then, my lord, 30 is the paragraph. I'll just read it for your lordship and then take your lordship to the other part. My lord, if your lordship comes down to 30 once. Insofar as the award of bonus marks is concerned, a careful perusal of the guidelines indicates that it was issued before the advertisement and all that it provided was out of the allocated 25 of the experience. Ordinarily, 2 marks were to be given for every year with a cap of 10 marks. However, if the experience is for the employee receiving honorarium under the projects run by the state government, then he was to be given 5 marks for each academic session. Even if a part of the experience was in a project to that extent, extra marks were provided to all the applicants. In the application form, there was a specific column, namely column 14, which asked about details of the experience. The form also asked for the name of the employer and the address of the institution employed. Thereafter, there was another column. It's the same thing that comes in. See paragraph 34. In Srinivas, a notification was issued inviting applications for the post of junior lab technician. Eligibility and requirements were prescribed. At the time of selection, the selection committee decided that out of 15% marks for the interview, 10% of the marks would be set apart for the length of work experience and or additional training in teaching hospitals of the medical college, with special preference for those who had worked in teaching hospitals of government or autonomous medical colleges, and the remaining 5% were to be assigned to the personality of the candidates based on biography. In the minutes, it was set out as under. Then the minutes are recorded. So, my lord, this is what has been done all throughout. It's not, my lord, for the first time that experience has been given some sort of weightage. And Supreme Court has held, my lord, that this can be done and this is a part of, my lord, positive discrimination. My lord, I hasten to add here, there's a very big pointer, my lord, in the Supreme Court judgment in Boishaki, which was the first judgment, my lord, which was the untainted persons, my lord, there will be no break in service, my lord, with respect to them. Kindly looks to that paragraph once. This is a pointer why, my lord, weightage should definitely be given, my lord, to these gentlemen. Kindly have a look at, my lord, page paragraph 47 of that judgment, of the Supreme Court judgment. Compilation আছে
First page.
Milord, it's the first page. And sees Milord paragraph 47.
Some of the appointed
Yes, yes, ma'am. Some of the appointed candidates who do not fall within the category of tainted candidates may have previously worked in different departments of the state government or with autonomous bodies, etc. In such cases, although their appointments are cancelled, these candidates will have the right to apply to their previous departments or autonomous bodies to continue in service with those entities. These applications must be processed by the respective government departments or bodies within 3 months, and the candidates will be allowed to resume their positions if they want to go back to where they were. Further, the period between the termination of the previous appointment and the rejoining will not be considered as a break-in service and their seniority. Now, my lord, why I am saying this break-in service is important is because, my lord, that they were working is, my lord, accepted, my lord, by the Supreme Court and given due weightage. That they were not in, my lord, we are victims of circumstances. What the Supreme Court did, my lord, was that they created a class out of a class. We were given appointments, but we were not people who were in any way related, my lord, to the misdemeanors. So we were given certain, my lord, advantages, and we are entitled to take advantage of, my lord, that of the advantages which is given, my lord, by the Supreme Court. So if there is no break-in service, and if I have gained experience, in my respectful submission, my lord, if the government has a policy of giving me, my lord, certain amount of weightage, I'm entitled to have that. It doesn't in any manner give the others any less importance, my lord, if they can come out, my lord, with in their own, my lord, merits. These are my respectful submissions, my lord.
The process cannot be challenged as a
If it is arbitrary, why not? No, my lord, that's grateful to your lordship. My lord, I had given to your lordship on the first occasion a note of argument. I don't know, my lord, in the jumbled up papers if there's,
check up.
my lord, I will give your lordship another one once everybody finishes.
Yes.
Then I will give it to your lordship.
There is a new matter which has been added, item 47, no difficulty. Because of the new matter, there is a new applications. I won't be repeating anything. Whatever I said already, it will apply there. Kindly allow that applications. Can 1 in item
In item 47?
47.
Yes, we have
Alright.
filed can 2 and 3, my lord, that's
Or-
not in the list. Today itself, my lord, we have filed. 2 and 3.
Today itself you have filed, how will it be there in today's list?
Not already we have reached quite a technology. So
Yes, yes. Who is the next one to argue? State?
It is content for your lordship. Can we come back on 27?
একটা অর্ডার লিখে নেন তো অ্যাপ্লিকেশন গুলোকে অ্যালাউ করবেন সবগুলো না শুধু একটা যেটা লিস্টে আছে 47 can 1 অন্যগুলো submission made on behalf of the added respondent. The submission of a few of the added respondents who are the job losers opposing the writ petition. Staff paragraph. Accommodation has been sought for on behalf of the learned advocate general. Staff release the matter for further consideration on 3rd of February 2026.
Not in can one, there is no order. In item number 47, my lord, there is no order passed, my lord, so there is no affidavits filed in item 47, my lord.
Correct.
It's a new matter, my lord. Fairly new matter.
না এটা তো 46 থেকে শুরু হয়েছে দেখছি দাঁড়ান
Because 47 was originally not in the list, so it has come
আচ্ছা
because of the similar matter.
7 has it been placed
No, my lord, not yet.
at all?
It is appearing in the bunch, so that's the reason.
My lord, the delay factor will also be there in this matter because it was filed in December.
All right. 47 is the petitioner here.
Yes, my lord.
You are there,
Let them execute those.
right? Are you aware what the issue is?
Take instruction. Sir will argue. Yes, ma'am.
Never say sorry.
Tell me one thing. Is the issue same in
It is same,
47?
because otherwise,
How same to this one?
what I say, because this could not have come because the all bunch matters were appearing in the list.
So this was mentioned and it
It was
brought.
mentioned, so I have seen the prayers,
Yes, it is the same.
so what I find, it is same.
All right. তাহলে 47 আজকে it is appeared for the first time. 47 এ তাহলে application টা allow হচ্ছে and direction for filing opposition. In that case, the matter will go over. You'll take some time to prepare your opposition.
Will take a week or two, my lord, for preparing an opposition. My lord, maintainability may be kept open because, my lord, it is filed at a very delayed juncture.
Lordship may kindly remember in one of the writ petitions, Lordship dismissed 9-10 experience. His question was how 19 experience can be used as an experience for 11-12, but he did not challenge a rule in a different writ petitions. This writ petitions, they challenge the rule, that is also incorporated. So if your Lordship take it, is it the identical on a point of prior experience? So I would not say that.
It's not restricted to only
it-
prior
yes,
experiences.
yes.
Other issues
it is
are
goes
also
beyond
there.
that. Yes, yes.
47 কে আলাদা করে অর্ডার করবেন application allow করবেন opposition we filed within আজকে 20 তো 6th of February. Reply if any by 16th. Released 24th of February.
Point of maintainability, my lord, may be kept open.
The point of maintainability of the writ petition raised by the commission is left open to be decided at the time of final hearing of the writ petition. 47 with করে আর appear করবে না
One time.
আলাদা হয়ে যাবে
Can one. All.
আচ্ছা
Take it.
হ্যাঁ 48 49
Well, this matter, my respectful submission is, Lordship is for the time being fundamentally deciding, is it constitutionally valid, intra-virus or ultra-virus? Probably once that is decided, all ancillary may be
follow.
decided after that.
which is the ancillary ones 48 and all this.
No, ancillary one is 47 itself.
47 is all right, separate order is 48. Is it the same thing, same
It
issue?
is same thing, my lord. The rules are challenged. It was filed prior to filing application form.
All right, in that case same order will go down সবগুলোতেই একটাই অর্ডার হ্যাঁ 47
48 is identical with 46.
আলাদা করে করে
এই যে
The identicals are, my lord,
একসাথে
46, 47, 49, 50, 51, 52. These are identical.
with করেই আছে
শোনেনি
40% আলাদা 40% আলাদা করে দিন
47
all right 50 হয়ে গেল 53
আমাদের নেই